We're following on quite a number of top stories here on the show, but we also have a discussion that has been ongoing here in studio. I'd like to continue with it. And Mambola, I didn't hear your thoughts about, petition. He says that, he hopes that the judiciary will not embarrass itself today.
Article 38 is extremely clear on political rights. Every person has a right to stand in an election, and every person has a right to vote. Now, having said that, then you resort back to common sense, really, even without delving into the question that is before the judges, because that would be what lawyers call sub judice. Yeah. This is what I have to say. In my view, if the law is a hindrance to anybody withdrawing from any election or any electoral contest, then it should be amended immediately so as to allow any person, once they express themselves unequivocally that they no longer want to participate in an election, that their name is removed, because there is absolutely no reason for creating any barrier, legal or otherwise, from the exercise of the right to stand in an election. And I think Raila Odinga is well within his rights to not participate in this election. By boycotting this election, the IEBC should even send information out there and say, Raila Odinga has said he's not participating, and if by any chance his name is on the ballot, just treat it like it was not there. So I don't want to engage in this technical discussion in which the IEBC is telling us that, he did not fill Form 24A or whatever other form. Raila Odinga has been out there giving extremely well thought, clear ideas on how he wants this election to go, and one of them has been, no, I am not participating in this election. So the IEBC should settle that question. But we have also seen a problem with the interpretation of some of these legal questions, even from the IEBC itself. Look, for instance, under the 2013 presidential election petition, the Supreme Court pronounced itself in what lawyers like to call obiter dicta, that, the people who are, or the candidates who are eligible for a fresh presidential poll are the president-elect, number two, if he is the one who contested the election, and any other candidate who contested the election. The other candidates in that election who chose to accept the results are treated as having accepted the result or acquiesced to that result, and therefore they should not be on the ballot. But we have seen a chairman, together with his commission, who come and tell us that, the only two people who are going to be on this repeat presidential election are going to be Raila Odinga and Uhuru Kenyatta, which was legally wrong, and which we didn't expect from a commission of the stature that Mr. Chairman Chebukati is leading. And then the parties go to the Supreme Court, and the Supreme Court says, hey, go to the High Court, because the High Court is the place where is the home of constitutional interpretation. Go there and get a proper understanding of really who should be in this particular ballot. And the High Court says, hey, every person who is entitled to participate is entitled to participate, except that, the time we have will not allow us to go into fresh nominations. So you guys go and get everybody who was in the ballot to be on the ballot. However, that does not even mean that you're participating. Your name could be on the ballot. That is what the court said. But it doesn't mean you're participating. All you need to tell your people is, hey, you might see my name there. In any event, you will not see it, because, if you're a NASA supporter and you have been persuaded that you should not vote, then it means you're not getting into the polling station, which means you will not even see his name.
If I may just weigh in, election management is not based on rumors and guesswork. So I believe IEBC's spectacular fail into the limited issue of management of candidates is well documented. They started very well, but they've been flip-flopping and listening to political voices instead of relaxing, reflecting, and observing what the law says and acting with clarity. Remember, in terms of election management, the centrality of clarity is an indispensable component. On 1st of September, Betty, the Supreme Court annulled the presidential election. On 5th of September, IEBC, guided by the Supreme Court 2013 judgment, and I think that was well placed, because insofar as Article 140, Sub-Article 3 says the fresh election may be conducted in 60 days, we don't have supporting laws or regulations that can deal with processual issues up to the date of that ballot. Now, what that means is that Parliament, for one, is not allowed to make those laws in the middle of, during this intervening period, but we could use judicial interpretation to provide clarity where there's confusion or controversy. Now, IEBC itself began by relying on that clarity part of the clarity in the 2013 judgment, when the Supreme Court was building scenarios, they said, where there's only one candidate who petitioned, the Supreme Court to challenge the election of the president-elect, that is the person to go back to the election together with the person who was declared. Based on that understanding, paragraph 290 of the 2013 judgment, IEBC then gazetted Uhuru Kenyatta and Raila Odinga as the candidates. Yes. And I think it's not fair to fault IEBC on that particular action, because I will ask you, pose a question, then show me the other law. Because there is no any other law in statute or regulation except the interpretation of the Supreme Court on what it means to conduct a fresh election and who is entitled to participate. Right. So on that limited question, IEBC got it right. However, Ekuru went back to the Supreme Court and said, I also participated in this presidential election petition, although not as a petitioner, but as an interested party. Lawyers know that if you participate in a petition as an interested party, you must demarcate. You must state and tell us, who do you support? Are you supporting the petition, in which case you're supporting Raila Odinga,
yes,
or you're supporting the respondent, in which case you're attacking the petition, in which case, if the judgment is made, you're not entitled to benefit from it, because what Mambola is saying, you acquiesce to that election result. Ekuru was on the side of Raila, and he had a good case, and the court told him, this is now a question of interpretation. In our understanding of the hierarchical order, in terms of interpretation of the Constitution, go back to the High Court, interpret with finality. And if you look at the order, the ruling by Judge Maraga, transmitting the question to Judge Mativo, it was very clear that the High Court has the original jurisdiction under Article 165, sub-Article 3, to interpret the Constitution definitively. But if you're not happy, then you can escalate it in terms of appeal until it reaches the Supreme Court.
Yeah.
The High Court, in its own understanding, explained what fresh election means. And it said, in our understanding, it is that all the 8 candidates, it's open to them, should they want to contest, to be included. Now, what IEBC started making mistakes, IEBC should have invited all the 8 candidates, requested them to communicate whether they want to participate or not. Raila had already said he had withdrawn. There is no legal justification for including Raila in a fresh presidential election when he has withdrawn. Jirongo was
but they said that he did not do that officially.
No. See, because already, under Article 140, people who are saying that Raila has not withdrawn formally, he didn't sign Form 24A, those are people who, the argument is not founded in law. If the justification for Form 24A, if you look at it, that is Regulation 52 of Election General Regulation of 2012 as amended, says, in fact, that regulation opens in these words: withdrawal of candidature after nomination before the general election. Clearly, Betty, that specific provision was intended to apply to persons withdrawing or candidates withdrawing before they progress to the general election.
Okay.
After someone has gone through the general election, the Supreme Court has ordered a fresh election. Surely that stage needed fresh laws, regulations, procedures, which for now we don't have. Because we don't have, you're not allowed to extrapolate a provision under Regulation 52 and say, fill from 24A.
Right.
That form, I believe, the communication by Raila, a written notification. In fact, the language used by the Supreme Court was that if a candidate abandons, the Supreme Court did not say if a candidate withdraws formally. The fact that the Supreme Court said if a candidate abandons an election, then you go to fresh nomination. To that limited extent, Raila had withdrawn. But what is also not open to Raila, and NASA must tell us openly, when the High Court interprets the Constitution definitively and says fresh election means all the 8 candidates, you can no longer rely on the 2013 judgment and say fault the High Court in terms of saying everybody should be included. If you want to fault Judge Mativo in a Ekuru case, you fault it by filing an appeal. They have not filed an appeal. Even if an appeal was filed, that appeal has not been determined. So, but I'm just narrowing what IEBC ought to have done on the missteps. IEBC ought to have invited all the candidates and say, hey, we have the Mativo judgment. Do you want to participate?
Yeah.
Raila says, I don't want to participate for reasons stated or not stated. Jirongo is not open to him to say whether he wants to participate or not, because at that time he was a judge bankrupt. What IEBC ought to have done in law, since Kenya is a multi-party democracy, it was open to IEBC to give the United Federal Party, Jirongo's party, an opportunity to replace that candidate, because it's not their fault that the candidate has been a judge bankrupt. The other persons had already declared that they wanted to participate. The question of printing ballot papers with Raila's name there, I think it's a question that if it were to be taken in court, that ballot paper would be found to be illegal. Justice Ringara, if you allow, briefly. Justice Ringara once said...
Let me bring in Mambola to hear what he has to say.
I just wanted to finalize just in less than 10 seconds. Justice Ringara once said, in the Njoya case, when the question of interpreting Section 47 of amending the Constitution, he said that there are so many things that happen out there, outside the court, which fortunately or unfortunately have not been tested in court. Had they been tested in court, much of them would have been struck as illegal or unconstitutional. I see the printing of ballot papers with Raila's name in it as one of that illegality that will go unchallenged because nobody has taken it to court.
All right.
Betty, that is the fickleness of this democracy, that it gives a lot of things on the one side and sometimes it could take on the other hand. You see, the framers of the Constitution are, or might not have been angels. They probably wouldn't anticipate every possible scenario that would arise in the process of a democracy like Kenya growing. And we must understand, for instance, that when all the chips are down, probably somewhere, the true spirit of the interpretation of this Constitution is going to come out. There is this 2013 decision that Supreme Court decision that we keep relying on. First and foremost, from where I sit, I think that obiter dicta on who should participate in the fresh poll was wrong, absolutely. And I think the correct position is a position that has been given by the High Court through Judge Mativo's reading. However, Betty, this is the problem, that I think what we fail to understand is that all this legalism, all this legality, all this constitutional talk surrounds a certain corpus of challenges that deal with the presidential election petition, presidential election. The presidential election is a political contest. You expect that it's going to be extremely emotive. It calls upon the players to invest heavily emotionally in terms of manpower, in terms of financial and other resources, and you don't expect it to be an easy task for either side. And so when you have something like that, the best route to take is to always look at what are the possibilities within the Constitution that can be used for purposes of resolving any dispute which arises within that particular contest. Okay? And it would really help if you get a consistent reading of the Constitution, not cherry picking, that, you know, this article of the Constitution supports my cause, so it is nice. Then the other article doesn't support my cause. Or you read probably the article halfway, where, for instance, you just decide to read that this Constitution under Article 37 provides me with that right to picket and demonstrate. And then you don't read to the end, which means that you should picket unarmed and in a peaceful manner while allowing the rest of the Kenyans to enjoy their rights, which are also guaranteed in the same Constitution. There are two important things that we must underscore. First and foremost, the electoral process in this country poses certain challenges to the existing system and the laws, but the electoral process in this country is not the only problem that we have as a nation. And it is true, yes, that we have several grievances coming out of various sections of this population which need to be addressed. But as I keep insisting, these grievances must be addressed within the general framework of the Constitution and the law. Because if you move out of this constitutional dispensation, then it means you are moving into a realm in which nobody will regulate the debate. It means you cannot parameterize the debate. It means you cannot effectively engage in a conversation as a nation. And today, as lawyers here, we are also Kenyans, and we also expect that this country will continue being here for us and future generations. And it behoves us, as we interpret this Constitution, to always put our country first and say, hey, we have seen many examples of people who have decided to go out of the constitutional order and try to look for solutions for political, economic, and other problems outside in the abstract, and the consequences have been dire. So for this country, can we re-engage? Can we soften our stances and agree, yes, this election is not going to solve all the problems that we have as a nation, but let's conduct it. That is the safer mode to be in as we get into a discussion on how to take this country forward.
All right, interesting. Great conversation we're having here in studio.